Hi everyone, my name is Kate Silburn and I own Rocky Mountain Elder Law, and today I'm going to talk to you about the different types of estate litigation that I do. We unfortunately have to face the reality that sometimes disputes arise in the elder law context, in the estate and trust context. What kinds of disputes are those? Well, the first can be a trust contest, and this can happen while the beneficiaries, of course, are alive, even the grantor is alive, and that means the person who funds the trust. The trustee is often the target of a trust contest because it could be that the trustee is not providing accountings or not treating the beneficiaries impartially or simply not making distributions or making distributions to themselves improperly. With guardianships, conservatorships, obviously the person who is under a guardianship or conservatorship is alive. They are being fought over in a guardianship, contested guardianship or contested conservatorship. So in those instances, the dispute often arises where the family members want control of mom or dad's or grandmother or grandfather's health care and well-being under a guardianship. But a lot of the time it has to do with the conservatorship, the money. So there can be litigation around who controls the money, but then there can also be litigation going after the conservator for bad acts, for breaches of what's called a fiduciary duty, meaning that a conservator, like a trustee, like a personal representative under a will, is obliged to act in the interest of the protected person, or obliged to act in the interest of the beneficiaries, obliged to act in the interest of the beneficiaries of a will. So a litigation can arise in many different ways. In a will contest, that is a kind of interesting area of litigation because a will does not take effect until someone dies. And what we want to do in a will contest, if we're trying to set aside a will or offer a will for probate and we want it enforced, there's several different kinds of tests that have to occur to prove a will's validity. And there are somewhat complex burdens of proof that go back and forth, but a lot of times people challenge a will based on incapacity when the person writing the will or signing the will, that is, doesn't have capacity, doesn't have the wherewithal to know what they own and who they want to give it to, and they're being unduly influenced by one person or another. And so there's lots of aspects to the kind of litigation that I do, lots of areas, but I must say that there is a part of me, as much as I love the planning and I love the getting everyone's ducks in a row, I do really relish the fights. That is not a negative thing. It is just that I like to bring families hopefully back together and get a resolution for them, whether that's through settlement and mediation or whether that's going to a full-blown trial. I'm very conscious of the fact that families are involved, and I approach it with a kind of holistic hope that families will resolve issues and that the fractures that are occurring within families will eventually heal and people can again come together as a family when things get resolved.